Today, we will talk about the exemption clauses in contract law. But first of all, before we explore exemption clauses and I give you some valuable advice on how to get high grades, I'd like to introduce myself. I'm Nini. I'm founder of Simple Studying. I have LLB and LLM degrees from City University of London. I've got high to 1 first class grades in my exams when I was a student. And then I started Simple Studying to help other law students as well get good grades and become lawyers. And I would like to tell you a little bit more about our project. So we're building an all-in-one platform for UK and US university students to get high grades and build successful careers. So we started with law, helping law students get good grades and become lawyers, but now we're expanding and we're also going to provide services for American students. Why you should trust us. We have over 25,000 registered customers already on our platform, mainly for law. And that's like 25% of total law students in the UK. 90% of our regular customers report to have got a first class, which is the highest grade in the UK, after getting our premium membership and at least 6 hours of tutoring sessions per exam. After working with thousands of law students in the UK, we know exactly how to get high grades and how to get a first class law degree. So if getting a first class law degree is your goal, you are in the right place. What is an exemption clause? Exemption clause, also known as exclusion clause, aims to exclude or limit the liability of one party for not performing their obligations in accordance with the contract. So in every contract, you get exemption clauses to limit liability of one party. Some very frequent exemption clauses include breach of contract, excluding liability for breach of contract, and excluding liability for negligence. What is the reason? Why do we need exclusion clauses? This helps reduce litigation costs by making clear what are the responsibilities and liabilities of each party. How to incorporate an exclusion clause in the contract? There are specific rules about how you can use exclusion clauses. If those rules are not followed, then exclusion clause will be invalid. First, it has to be incorporated in the contract as a term. Second, it has to cover the type of loss that has arisen. Like, for example, if it's an exclusion clause for negligence, is the exclusion clause specifically saying that liability is excluded for negligence? So it has to be covering specifically for the type of loss that has arisen. Then third, it should not be rendered unenforceable by statutory provisions in the Unfair Contract Terms Act 1977 or Consumer Rights Act 2015. Unfair Contract Terms Act applies to business transactions, whereas Consumer Rights Act applies to consumer transactions. So depending on what kind of transaction you're dealing with in the problem question, you have to apply the relevant statute. These are the ways you can incorporate the exclusion clause in the contract. And in a problem question, you will have a scenario where you have to assess whether or not the clause was incorporated. So you have to discuss all these three and see which one is relevant and how, if the exclusion clause is incorporated in the contract. First is signature, second is notice, and third is previous course of dealing. Incorporation by signature. The main case is Lestrange. This is a so-called parole evidence rule. Signature is a valid consent to the terms of the contract. So even if you don't read the contract, it doesn't matter. If you sign it, it's enforceable. So nowadays, we sign up on so many websites and apps, and we always agree to terms and conditions most of the time without even reading it. Doesn't matter if you read it or not. You are still bound by the terms if you sign it. Requirements for incorporation by notice. So what are the steps for incorporating the exclusion clause in the contract by notice. Notice must be given before or at the time of contracting. So the timing is very, very important here. The case is Oley versus Marlborough Court. A notice of exemption clause in the bedroom of a hotel was held not to be incorporated into the contract because the notice was not seen by the guest until the contract was concluded. It was seen after the contract was concluded, whereas the requirement is that the notice must be seen before or at the time the contract is concluded, not after. The term must be included in a document in which contractual terms would normally be found. For example, in case of Chapleton versus Barry, the exclusion clause was on receipt, and the court held that the receipt is usually not a document where you would include important contractual terms, so it was not valid. So it must be in a relevant document. Reasonable steps must have been taken to bring the terms to the attention of the other party. The case is Interfoto versus Stiletto. It was held that a party who seeks to incorporate into a contract a term which is particularly onerous or unusual must prove that the term has been fairly and reasonably drawn to the attention of the other party. So what does this mean? If there are some unusual terms or some very important or specific terms that are usually not present in such kind of contracts, it's not enough to just include it in the terms and conditions and make the people sign it. You have to somehow draw their attention to it. For example, when you sign up for apps or subscriptions online, usually they will tell you if the subscription is subject to recurring payments. Even though it is written in the terms and conditions, they usually tell you on the sign up page as well in very visible letters, like that is impossible to miss, because they want to draw your attention to the term that you will be charged recurring payments. That is like an example of unusual terms that must be drawn attention to before the contract is concluded. Incorporation by previous course of dealing. The case is McCutcheon versus McBrien. The courts have never defined course of dealing, but there is some guidance in case law, such as this case. There must be consistency. So if the court says that there is inconsistency between cases and in the industry, and it's not a well-established rule, then they won't enforce it. It has to be like consistent course of dealing for an exclusion clause to be incorporated in the contract this way. So in a problem question, you should follow this structure. First, you have to identify the exemption clause. Usually they give you in a very, like they tell you this is the exclusion clause and it's impossible to miss it. But make sure that you like analyze the exclusion clause really well and understand what it means, and then discuss if it is validly incorporated in the contract. According to what we just discussed, the ways of incorporation of exclusion clause in the contract, you have to discuss if it was validly incorporated. If you think it was, then you have to justify. In law, you cannot just say, yes, it was validly incorporated or it was not. You have to justify your answer by applying the relevant case law, by saying which one applies. Is it signature? Is it notice? Is it a course of dealing? Could it be multiple of them? Could it be both notice and signature? So you have to like apply the relevant case law and make arguments and provide critical analysis. Third, apply Unfair Contract Terms Act and Consumer Rights Act. Unfair Contract Terms Act is relevant for B2B transactions, business to business, whereas Consumer Rights Act is only for consumer contracts. So you have to understand in the problem question that is given to you, is it a consumer transaction? Is it a consumer buying the product or service? Or is it a business? So you have to apply the relevant statute according to what kind of transaction it is. And finally, apply the reasonableness test when relevant. Unfortunately, we didn't have time to cover the reasonableness test in detail, but please go to simplestudying.com and there we have everything covered in detail. Videos, study notes, everything is there. But briefly to tell you, reasonableness test is set out in section 11 of the Unfair Contract Terms Act. And you have to apply it in certain circumstances, not all the time. So you have to have a look at when to apply, and if relevant, then do apply it. If you go to simplestudying.com and search contract law, you will find all the revision notes, case summaries, model essays, quizzes, tutorial videos, and flashcards, everything you need to get high grades without reading overcomplicated books, textbooks, thousands of pages of textbooks that they usually give you at university. So our platform replaces the need of you reading overcomplicated books. We also highly recommend you to book a tutoring session. If you just click here, you will be able to book a tutoring session, or here. But the most important is that you study with our study notes, because it is very simplified, condensed, drawing your attention to what is important to know to get a first class. And then also, I suggest you watch the tutorial videos as well for revision. Tutorial videos are not very well detailed. For details, you should read the notes. And if you need like specific case summaries, you can visit case summaries as well. Model essays are great because it gives you like example questions and answers that you need to understand how to write problem question and essay questions. So model essays is like an example showing you how you're supposed to answer problem and essay questions. Quizzes and flashcards is just to practice your knowledge and memorize the important information. But tutoring sessions are extremely important, especially if it's your first year, because you need personalized guidance to understand how to answer problem and essay questions.